Our next conferee is Professor Stephen Ware. And I know Professor Ware's testimony will be the larger packet in your materials, so I would remind you, we'll have a little more time, but if you can keep your remarks to hopefully around 12 minutes, that'd be great.
Thank you, Mr. Chairman. My name is Stephen Ware. I am a law professor at KU. I speak to you today not on behalf of KU or anyone else, but on my own as a concerned citizen. My academic research and writing on judicial selection began in the 1990s, and I have in recent years increasingly specialized in the area. My academic interest is not just in Kansas judicial selection, but covers the entire nation. My writings speak to judicial selection around the country, and I travel to various states when I'm invited to give talks on judicial selection. I've spoken on this issue in several Midwestern states, Missouri, Indiana, Iowa, and some states in other parts of the country as well, Florida, Texas. In some of these states, I have given legislative testimony. I believe I have developed a significant expertise in the various judicial selection and retention methods used throughout the U.S. My research articles, which the chairman pointed out are attached to my testimony, my research articles show that the Kansas Supreme Court selection process has 3 flaws. It is undemocratic, extreme, and secretive. Undemocratic, extreme, and secretive. All 3 of these problems would be fixed by SCR 1601, so I strongly support it. crucially important. Who picks the commission? And the Kansas Commission is picked in a shockingly undemocratic way. Most of the members of the commission are picked in elections open to only about 10,000 people. The remaining millions of people in Kansas have no vote in these elections. This violates basic equality among citizens. The principle of one person, one vote. The current system concentrates tremendous power in one small group, the bar, and treats everyone else like second-class citizens. In a democracy like ours, a lawyer's vote should not be worth more than another citizen's vote. As Washburn Law Professor Jeff Jackson wrote, democratic legitimacy, quote, would appear to favor a reduction in the influence of the state bar and its members over the nominating commission because they do not fit within the democratic process. That's the main point, and it's made very well by Washburn Law Professor Jackson. The current process is undemocratic. It makes 10,000 people, not elected by anyone, more powerful than everyone else in the state combined. I think this is all anyone needs to know to want to change this system. But the case for change is even stronger when you compare Kansas with the other 49 states. Kansas is the only state that allows its bar to pick a majority of its Supreme Court nominating commission. This is my second big point, so I'll emphasize it. Kansas is extreme. No other state is as undemocratic as Kansas. None of the other 49 states gives the bar so much power. Kansas stands alone as the only state to allow its bar to select a majority of its Supreme Court nominating commission. Some other states do have nominating commissions with some seats reserved for lawyers. But the important question for democratic legitimacy is not whether a member of the commission is a lawyer. The important question is who picks that member of the commission? Who picks the pickers? And again, no other state is as undemocratic as ours. My third and final point is that the current system has the problem of secrecy. Not only does this system concentrate tremendous power in a small group, but that power is exercised behind closed doors. The nominating commission's votes are secret. There's no public record of who voted which way. In contrast, a Senate confirmation vote is public. So 1601, by replacing the commission with Senate confirmation, would increase the openness of the process. In addition, Senate confirmation would fix the current system's problem of being undemocratic. While elections are direct democracy, Senate confirmation is a form of indirect 11 states have their Supreme Court judges confirmed by their state senate or similar popularly elected body. And experience in those states shows that Senate confirmation works well at the state level as well as the federal. And importantly, those judges who went through Senate confirmation are every bit as good as judges selected in a commission system like Kansas has. You don't need to trade off judicial quality against democratic legitimacy. If you choose a Senate confirmation system, all of the evidence suggests you will get just as good judges as you get under the current system. In conclusion, I believe that no process of judicial selection is perfect. But my research and reflection has convinced me that the least imperfect process is the Senate confirmation system. Getting the least imperfect process is the best we humans can achieve. So long as, to use James Madison's words, men are not angels. We don't want a judicial selection system designed for angels, because we know most people and even most lawyers are not angels. In sum, Senate confirmation of Kansas Supreme Court justices is a wise and prudent reform that will move Kansas